Oh, I'm.
Oh, no.
Yeah. I kind of think.
Oh, like, listen, then you didn't send it. No, I think you gotta do it by sentence.
Satisfied. Yeah.
Sorry.
Do you have a village still?
Yeah. We are aware.
I'm getting have a.
Yeah, Bob's in the 10 to 15 minutes late.
Upper, Zabel's.
You're also. How are we doing there?
We are ready to go.
Well, we can do the business check.
Yeah, yeah, it's such long.
In accordance with the Open Public Meetings Act, please note the following: all Bernardsville Borough Planning Board meetings will be held in person in the meeting hall on the second floor at the Bernardsville Municipal Building at 166 Brook Road. Thank you. Meetings will be live streamed on YouTube, but with no opportunity for public comment. Members of the public wishing to offer comments or ask questions will be required to attend meetings in person. YouTube live stream access for all meetings is YouTube at Bernardsville Borough/streams. This link will also be available on the agenda for each meeting, which is posted on the Borough website and on the Borough Hall Public Bulletin Board at least 48 hours prior to meetings. Notice that these changes have also been emailed to the Bernardsville News and Courier News by posting a copy on the Borough website and by filing a copy with the municipal clerk on January 16th, 2024. It's the intention of the board not to continue any matter past 11 p.m. at any regular or special meeting of the board unless a motion is passed by the members and present to extend to a later specified cutoff time. And same shall be announced at the opening of each meeting. In addition, the board does not intend to begin a new hearing after 10 p.m. or begin testimony of a new witness after 10:30 p.m. Any hearing conducted by the board is a quasi judicial proceeding. Any questions or comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision. The quorum appropriate to a judicial hearing must be maintained at all times. Roll call.
Yes, Mr. Chairman, Mr. DeMarco is absent. Ms. Gardner is absent. Ms. Geller. Present. Mr. Graham.
Present.
Mr. Horowitz.
Present.
Mr. McQueen is absent. Mr. Simoff is absent. Mr. Walden.
Present.
Mr. Zazarino.
Present.
You have a quorum, Mr. Chairman.
Thank you. Okay, no meeting minutes. Communications, first two are just notices from the Soil Conservation District. Number three is the climate change hazard vulnerability assessment. And then we have sections from the Bernardsville Parks and Recreation Master Plan from July 2021. So anyway, climate change hazard notifications.
I think there's just the letter from,
The proposal.
John.
for emergency
John,
policy.
okay. Okay. We can discuss that, we'll discuss that later.
Yes, I have it on after
Yeah.
the application, Mr. Chairman.
Okay, so, now it's quick, if there's anyone here to discuss something that's not on the agenda tonight. Now is the first of your two times to, speak up and state what your concern or question is. I don't see anybody. We have no old business. So for new business, and the first item is comments about the Equinet application. So, Steve?
Happy to help, Mr. Chairman, thank you. As you'll recall, the Equinet application was a situation that protracted somewhat. We were concerned about not having sufficient time to act and even got to the point where we were going to adopt dismissal without prejudice resolution. The applicant has confirmed they are proceeding with the application. I believe, but we don't have plans yet, that it's a modified application and perhaps a scaled down application. If I understand correctly, it's my understanding, Denise can correct me, that we might be looking at a November hearing date for that, and they have given us an extension of time to act through the end of the year. The only reason why they haven't given us one longer than that is because it'll be a new term from January, and if we're not resolved by that point, they've already indicated they'll you give the board plenty of requisite extensions of time to act, so we don't have the problem we had previously. So incumbent upon the board to hear them. So we don't have to schedule as a board, it's, I guess, more of an update to the board to confirm all the above, including most importantly, the time to act extension.
When they resume this, what would the board member qualification considerations be? Will this sort of be considered a reset? And
Well, it would still be the same application, just as often happens, plans and applications get amended, revised throughout the process. So it would be incumbent upon our board members to, if they have not, we're not there for any meetings, any hearings, and we're just missed interim ones, to get up to speed, so to speak, so they can certify before they vote.
maybe we should just tabulate that for next meeting or something, just to let people.
Certainly, apparently we have a couple of months still, or almost a couple of months before we have to worry about it.
Yeah, what about board members who were not on the board?
No difference. And that's the law with all matters. Whatever the reason that you weren't at the prior hearings, effectively, it doesn't matter. It's the same process as long as you read the transcripts and or watch and listen to the recordings. Then you qualify yourself under the municipal land use law, sign certification, and you're as good to go as a member going back many, many years.
And just one other thing I'd like to add, if I may. I did speak with, another attorney at, Mr. Kronos's office, but Mr. Kronos has represented the applicant. I spoke with her yesterday and today. They were requesting to possibly, they're gonna be getting plans in the next couple of days. They were requesting to possibly be heard at the October meeting. And I explained to them, we've already got something scheduled. So that's why I said to them, we can tentatively think about November 14th, depending upon when we get everything in and what happens between now and then.
Notice, do they have
Correct.
notice?
Although we know, yes.
Have to be noticed, because it's been.
October 10th, isn't there another meeting on the 25th? It's every 2 weeks.
Yeah.
Yes, but we've got things going. We have another application on that. We've got things both that nights. And this isn't one. I don't know that it would be able to be done like with another application the same night.
Depends on the other app, yeah.
Yeah,
What these, do you already know what app that is?
it is. hold on the agenda,
And, then,
Police.
yeah, 2 weeks.
Puglisi, that's the site plan for the restaurant.
Right, for the Walters.
Yes, and then. We have another. Minor subdivision. We have the minor subdivision on the 10th and then the restaurant, on the 24th.
I would think we can. Two. On the 24th, the restaurant, because they're repurposing the building, right? I mean.
Well, and the,
The other one's on the 10th.
the ethical matter is just really. Dividing one line.
Yeah, I just think the timing, they can't get it to the 10th. Right, so it's not gonna carry this.
No, but we said they could get it on the 10th, but we weren't available.
I think they were looking for the 24th, but I think I may have seen the same email you're referring to.
Yes, well, I said October, I didn't say which one, but yeah, it was the 24th they were looking for.
So, not that it's a legal issue per se, but maybe it's best for them to submit the plans before we worry too much about whether it's the 24th or the November.
Yeah,
or
well, and
happens.
that's why I said I couldn't commit, because I don't.
Well, that's true, so, but the key is, I wouldn't say at this point we rule it out, that's all.
No, but exactly, we could always schedule it, they can notice, and whether they begin or not, they can, continue the next meeting in November.
Right. Okay,
All right, so I guess when I get the plans, I'll reach out or
well, yeah, let them, I mean, whatever you've done, you've given them guidance, you just say, look, well, let's see how it goes, that it's not precluded that they 24th,
Right,
let's see what progress they make.
right, well, and they would be second on the agenda.
That's okay, sure.
Okay,
All right, so that was that, and that, and so we've got all of those, all right, so. It came right in, here's your second opportunity to ask questions, if you're a member of the public and you wanna ask questions about something not on the agenda. I'm sorry, you skipped something.
Yeah, we skipped a little bit here.
I skipped the review.
yeah.
And that, so quite a bit actually, and I'm not just talking about the bills, but. The bills are just,
Discussion items, I went right, okay, the public hearings, I jumped right ahead to the review. All right, so why is that public hearing, so,
well, there are.
oh, the bills, we're gonna do the bills first.
Not that I have a vested interest in that, Mr. Chairman. But perhaps I have an invested interest in it.
Yes, all right, so anyway,
I'm just looking out for my colleagues to my left here.
in the memory of Terry Thompson, I was trying to rush through it. Okay, anyone have any comments on the bills? I do, but anyone else? I realize the last 2 months have been pretty exceptional from the standpoint of our legal representation. However, I certainly do not expect to see bills from Steve or Matt charging us for the time that you're taking to coordinate your coverage. That's not a customer billable item. Now, if you're collaborating on strategy or something, okay, that's fine, but a phone call to each other to say, this is how we're gonna cover is not customer billable. So,
Any of those will be removed,
yeah, that's,
and any approval of the bills would be contingent on any, but not
I
every.
understand.
Obviously, there's at least one, so all of them will be removed.
Okay, that's, I know it's minor compared to everything else, but. Okay. Thank you. Anything else, guys? And for now, we would approve the bills as listed and they would make this.
Motion. Second? Mr. Horowitz, you're taking a second?
Yes.
Thank you. Okay, Ms. Geller? Yes. Mr. Graham?
Yes.
Mr. Horowitz?
Yes.
Mr. Walden?
Yes.
And Mr. Donarino? Yes. The motion carried.
Okay, great. Let's get the head was on the back of the case. Okay. So now, public hearings, Zayler and Catherine O'Connor. This is a discussion of amendment road lot 32, lot 15. It's a lot line adjustment. For that property.
Good evening, Mr. Chair, members of the board professionals, Frederick Zelli Post Pollock on behalf of the applicants. And officially, Jeff Matalona, who's not officially an applicant, but is certainly as invested and involved in this as the named applicants. As indicated, this is the application of Benjamin Zeiler and Catherine O'Connor. And again, Jeff Matalona as well. This is regarding 1-1 Menham Road and 161 Claremont Road. It is purely a lot line adjustment. There are no variances involved. It's as straightforward a lot line as it really could be. I'm going to have Mr. Parker, our engineer, go over the basics and what's going to result. I do have Mr. Mataluna present. I will suggest that he be placed under oath, but I don't intend to elicit direct testimony from him. He'll just be available should the board have any questions that are kind of non-technical that Mr. Parker might not be able to address. Unless there's any questions for me.
Any opening questions from?
Yeah, I just want to confirm, just for the record, you may have noticed that I didn't do my usual, I think the legal term is spiel about the notice. Minor subdivisions under the municipal land use law do not require an LUL notice. As long as it is purely a minor lot line adjustment or minor subdivision, without any variance relief. It's my understanding from the applicant's professionals, that there's no variance relief. I haven't heard otherwise from any of our professionals. Hence, the board does have jurisdiction to hear and decide the application unless and until, frankly, if a variance were to quote unquote pop up, that's another legal term, during the course of the hearing, well, then we might have an issue. So we'll keep our eyes on that.
And for the record, we agree with everything Mr. Warner just said.
And then I'll stop talking.
That's all it takes. Rick, you're kidding.
That's right, that's all it takes, at least for the time being.
Then there's no other questions. I would ask that Mr. Parker and Mr. Matalone be sworn. Jeff, why don't you just come up and just take a seat?
I'm sorry. Do you please raise your right hand? Do you swear to God or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes,
Thank you. And then all of our board planners can do the same. If you'll raise your right hand, do you swear to God or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you both. Thank you. Back to you, Mr. Chairman.
all right.
Mr. Parker, first of all, just for the record, would you identify yourself, your place of business, and your occupation?
Yeah, my name is Steve Parker. I'm with Parker Engineering. I'm a licensed professional engineer in the state of New Jersey, employed by Parker Engineering, Somerville, New Jersey.
Your license as a professional engineer in the state of New Jersey is still in good standing this evening?
Yes, it is.
Have you appeared in front of this board before?
I have.
Does the board have any questions for him?
Accepted.
All right, thank you so much. Mr. Parker, would you please take us through the basics of this application? Let us know, please confirm for the record that there are no variances required in order to accommodate what we're doing.
That's correct. The plans that we have been submitted to the board have a revision date of August 2nd of 2024. So I'll just talk about that, describe what we're showing on the plans there, but I think as Mr. Zelli described, it's a simple lot line adjustment. It's classified as a minor subdivision, even though we're not creating any new lots as part of this. What we're doing is simply taking property from one of the lots, lot 14 in this case, and adding it to lot 15, making lot 14 a little bit smaller by about just under 13,000 square feet, and making lot 15 bigger by the same amount. The reason for that is just to give more usable area for the owners of lot 15 so they can enjoy their property. So again, there's no proposed construction changes, grading, or anything else. The proposal is to remain exactly as is, just move the lot line. And you can see that's shown on the plan. On the left-hand side of the drawing, you can see there's it's a hatched area, somewhat irregularly shaped, but it kind of surrounds lot 14. That's the area I'm sorry, surrounds lot 15. That's the area from lot 14 that's being added to lot 15. So you can see it's getting it actually quite a bit larger. Right now, the existing lot 15 is about 11,259 square feet. And it's going to be just over 24,000 square feet. So it's, basically doubling in size. And again, that same amount is being reduced from lot 14, but that lot is oversized as well. It's not causing or requiring the need for any variances. The setbacks will all remain the same. The lot areas are changing. And we've provided some calculations. You can see down in the charts below there, demonstrates what the setbacks are, what they're going to be, and then also what the lot coverage numbers are, the floor area, numbers are as well. So it's, yeah, it's pretty simple and straightforward. There's, like I said, there's no changes proposed, to either of the homes or the properties, as part of the application.
And just to be clear, there are setbacks that are changing, but none that are becoming.
I'm sorry,
compliant.
yes, I'm sorry, that's correct. Yeah, this is obviously some, because the lot line is moving, some of the setbacks will be changing between, basically between the two houses. Because the lot line between those two properties is getting adjusted, so they're still gonna conform, and they're gonna comply to what what's required in the zone.
Thank you. Nothing further for Mr. Parker.
Yeah, I believe that the documentation should be examined as well as the deeds in terms of the specification of lot 14 versus its address, 161 and 163, and some of the tax rolls is 163 owned by 161, which doesn't appear to exist.
So you're just talking about the street number, the way the
Yeah, the
text.
street numbers and and the deed's gonna be by lot number, right?
Correct.
That'll be,
And not to mention meets and bounds,
but
correct?
there'll be, yeah, I'll get into that in a minute a little bit, but, there's confusion. There's an element of confusion here. Two street numbers already on the plan.
Well, it gets even more confusing because you have yet a third body involved, which is the federal government, the US Postal Service. When it comes to the street numbers, they tend to get involved.
Yeah, no, I'm just saying, let's double check, because New Jersey, the state of New Jersey says it's 163, not 161. And the documentation here says 161, so I don't have any issue with it, just make sure it's all clear and.
Since Mr. Madeline is here, let me just
since
ask
they're
you that
looking at
question.
it
Have
and-
have you ever had any issues with 161? Is that the number that you
One
use?
61 is the side I live in, it's a legal two-family, 163 is a tenant side.
Is the what?
Tenant side, it's a legal two-family
Oh,
house.
all right.
Yeah, 161 I live in, 163 is a tenant, all the same,
So this is two family.
yeah, zone.
That's-
All right, so what we
Yeah.
could do, we can
Yeah.
identify it as 161-163 to clarify the issue.
Yeah, and that's what I originally thought, but then
Got
I
it.
looked it up and I was like.
Yeah, sometimes it-
163.
people-
All I'm saying is. Just, you have the opportunity, you're gonna be going through paperwork, just try to get everything consistent on it, that's all.
We can absolutely do that.
Doesn't-
Easier.
we're dealing with lots, so. The other comment I have, and I'll have to ask, John Zabo on this as well, but it appears to me that the section of lot 14, right, which is the original lot, the donor lot is 14, right?
Correct.
Okay. As you know, that span between, zone R5 and zone R4. We have a straddle condition in zones.
Correct.
Now, it seems to me that the section of property that remains with, lot 14 actually would need setbacks conform in the rear of the lot and the sides of the lot. Or the sides would need setbacks conforming with the R4 setback requirements, that the entire property is not treated as an R5 property. Doesn't impact that, I don't think there's any impact, it's a drawing thing, but I don't know the case law where if you have a straddled property, a property that straddles zones, what the ruling is on setbacks and.
You measure setbacks from the lot lines, not the zone lines.
Right, but they have different requirements in each zone, so the rear setback in
do
zone
they-
4 is
Does it
40
change?
feet, not 25 feet.
One pertinent question may be,
This means
do they comply with these?
still complies. It doesn't clear.
Are you rendering, are the setback, do the setbacks remain compliant with both?
Under either zone where they.
Correct, yes.
I don't think it'll stop the application. It's more of a question about documentation and what's depicted, and this shows a 25-foot setback at the back of the property, when in R4, which is where that is,
It would be
it'd be 40 feet.
40, right? but as long as it's still compliant,
Doesn't stop.
right, no, I know, what I'm saying is prudence would dictate that, you use the more conservative setback, for purposes of,
Have we done that already?
They
Use the more
it's split in
It's
lots,
not gonna jeopardize
It would be
the
right.
application. It's
So-
still a matter of how it's documented.
So we can certainly accept as a condition of approval that we would revise the plans to reflect even both, if that's what would be preferred, they could be labeled
The
accordingly.
zoning ordinance doesn't address split lot situations like this. We've
Yeah.
talked about it in the past. I think it's gonna be a judgment call on the part of the board. I think in the past, I'm going, a vague recollection, whatever the majority of the property said, we've been using that. But this seems to be split directly in half between the park board.
Well, the majority was.
Yeah,
and
right.
Before,
Now they're pushing along.
yeah, so we have to look at the Zabo effect, remember when you had the split zone?
Well, what we
And
did
you
was, we
showed
recommended
everything.
zone changes, and we moved
Yeah.
zone lines to kind of coordinate the zoning with the property.
Yeah.
See, there are provisions in zoning where codes provide for adjustments to follow lot lines within certain feet.
Mm-hmm.
We don't have that, and this is way beyond anything I'm familiar with in terms of line adjustment.
I think it's easy enough to show, I don't think it impacts the
No.
application.
No, the main thing I looked at here was, does the subdivision create anything new? And by virtue of moving the lines, you're providing additional usable area to the lot above. So, you know, that was the main concern. Everything else is remaining the same, including the setbacks. And the information that I requested has been provided on the revised plan. That was most important because I wasn't sure if they're gonna meet other requirements like floor area that they do. That was the purpose of my original review.
But
Would the recommendation be to reflect the more conservative setback on the plans, or to identify both of them and label?
my recommendation for the recommendation of the board is that, or particularly if you're stipulated to it as condition of approval, is that you show both. Show both, that way you got the more conservative and the less conservative, you show compliance both ways. But.
you're already sort of doing, you see the lot circle that you put there, right, which is cool, that's an R4 lot circle. Right, okay, and you put the R5 lot circle down in the R5 section, so. I would agree with Steve, just. As a condition, just say, well, put them both down, like I say, I don't think it impacts anything, just
It's informative, it's, it's,
include.
maybe luckily this isn't a document that'll be recorded, so the ability to confuse the public is minimized.
Including the garage, right, for instance, it's not like the R4 side setback would jeopardize the masonry garage. Now, I'm also, because it is R4 and R5, we're agreeing that there will be no zone realignment action associated with this.
No, you're not.
I'm just getting concurrence, that's all.
Yeah, no, you're not changing the zone line.
Unlike,
No, just the lot.
other
lines.
places where.
Yeah, you're not rezoning the property, by virtue of minor subdivision at all. The ultra buyers borrow terms, no, that's good. Still 1 year terms. That's what you have.
I think, that's not relevant, never mind. Something. Any other,
So there's nothing proposed on the lot that's obtaining on lot 13. I mean, lot 15, and he gives them more land, so down the road, they may come in for something because they have more lot to cover.
Hopefully they won't need any, I need to come in here anyway, by the, if the board grants the approval, yeah.
Mr. Parker, just for the record, there are some further revisions suggested in Mr. Brightly's August 13th report. Are we able to accommodate all of this?
Yes, we are. Mr. Briley mentions, in his letter dated August 13th. And I'm just gonna go to, well, he's got a couple comments I think the board needs to discuss. Comments number 1 and 2 are just really comments, about the subdivision describes what's going on. Comment number 3, is a, comment for the board to consider, which is that, the the house on lot 15, excuse me, we're showing it as a 39.9 foot rear yard setback to McWilliams Terrace, which is a private road. Mr. Bright's comments just says the board may need to confirm if that's considered a front or a rear, just because I think because it fronts on McWilliams Terrace, or it has frontage along McWilliams Terrace. That's not how the property is accessed by cars. It comes out to Mendon Road, through a shared driveway with lot 1. But I think that's something that Mr. Briley suggested the board talk about, and I can just go real quick through his other comments. He recommends that some of the calculations we had on the plan were incorrect. We've redone those, and we'll change the numbers on there. It doesn't affect whether there's any need for a variance or anything like that. His comment, letter B and C, actually in D as well, just recommends the calculations were the wrong zone. I redid them. Again, they still comply. There's some minor differences and changes. We'll reflect those on a revised plan and send those back in. But I think the important thing is for the board to look at whether that rear yard distance of 39.9 feet is considered a rear yard or a front yard. I think
Well, the front yard is gonna control how you calculate the allowable impervious surface, so. Could leave it up to the zoning officer later, or if there's. They're gonna comply, it's just. I don't believe they're allowed access to McWilliams Terrace. So they're calling the front yard, the proposed subdivision line as their front yard setback.
Yeah, well, I would guess the way the house works, and then you can attest to that is that the front of the house is considered to be the side that has the porch on it. That's sort of how it works.
Yes, sir. Oh, yes, sir. Yes, sir.
The driveway, comes into the front of the house where the garage is. And as you say, the driveway exits on the Mendon. And so that would be the perspective, and if that were the front, because it's operationally the front, you still have like what, just a 3-inch short fall on the rear, but 40 feet instead of 60.
Right, it's an existing, it would be an existing non-conforming.
Yeah.
Setback, it's not.
Great, okay.
So if the plan is, depending on the board is, the plan is correct, that's the front yard, then we can nail down what the allowable impervious.
Correct. Right, and the new front yard would be vastly larger now, right,
Yes.
because of the acquisition of the expansion, so, okay, sounds to me that that's all was.
Yeah.
Just, Bob just wanted confirmation. You were up to point 3, I think.
Yeah, I was going through the letter and that was point 3. Point number 4, just request lot closure calculations and meets and bounds descriptions. Those would be provided, of course, as part of the prior to any approval. Point number 5, the subdivision will be filed by deed, not proposing to file a map. This will be just done by deed. And then comment number 6 is that approval is required from the Somerset County Planning Board. Claremont Road is a county road, so it's been submitted to them already. They come back with some comments. We revised the plans, sent them back to them. We just haven't heard back. We've got an approval letter from them yet. But that will be supplied as well.
And your revisions were able to accommodate all of their concerns?
Yes, it was, yeah.
They're both county roads, right? I mean, Claremont and.
Yeah, right, sorry, yes.
Okay. That was the end. That was the end of the comment.
That was, yes, sorry, yes, that was the end of the letter, yes.
No special utility considerations. Obviously, you're not changing anything like the shared driveway, whatever that is, that's whatever it is existing.
No physical changes whatsoever being proposed.
Any other comments? Any comments for our professionals are huddling? here?
No, we're just looking, just
Checking
checking zone lines.
Okay.
That's what they do when they have a little free time.
No comments more from the board. Think, you can.
Nothing
I think
further
you
from
can,
us.
You know, we'll give them, a minute, but
And you have
you're all right.
all your comments to take care of.
Yes.
And you had no comments,
I'm done.
other than, or no,
I have no
questions.
no questions, satisfied.
And so I think the board
So
members
we
don't
can
have any
accept-
public questions, public
Questions.
comment, if that's your last.
There's only
witness.
one witness, so.
Yes.
Does anyone from the public want to speak, either have questions for this witness or do they want to, comments, any comments? And then I guess you can stop.
So it's a straightforward lot line adjustment. We're taking just under 13,000 square feet from one lot, namely 14, giving it to the other, namely 15. In addition to making 15 a more manageable lot and a more beneficial lot. To some degree, it also kind of makes your shapes a little better in a way. Again, it's really an as of right type of application. Of course, the board has the jurisdiction, and that's why we're here this evening. But with that, we thank you for your time and would appreciate a positive vote.
And if it assists, Mr. Chairman, if minor subdivision by way of lot line adjustment, we now have confirmation from our planner as well that there is no variance relief or any other regulatory relief required. The conditions of approval, as I have them, would be compliance with Mr. Bradley's. There's the date. Oh, there it is.
August
13th, 2024 memo, and specifically, the table of zoning requirements to be revised pursuant to, the increase on number 3, with the presumption that effectively the new lot line is the front yard setback line for lot 15. And the requirements would be revised as conditions of approval in the revised plans accordingly, as well as lot closure calculations, the subdivision filed by deed reviewed by the attorney, and the approval or exemption thereof from by the Somerset County Planning Board, as well as confirmance, or I should say, when I review the deed, we'll make sure that the changes were made to clarify the street addresses, I guess, 2 street addresses on one lot, and then 1 street address on the other. And the plans will also show all setbacks, both R4 and R5 related setbacks for the split zone lot or split lot zone. I think it's split zone lots, that they always say split lot zone. And those are all the conditions I have.
Agreed.
So it would be a motion to grant with all those stipulated 2 conditions, if it's a motion to grant, and 3 out of 5.
Okay. Ms. Geller,
Yes.
Mr. Graham,
Yes.
Mr. Harwood,
Yes.
Mr. Walden,
Yes.
and Mr. Zazarino.
Yes.
Thank you all so much. Have a wonderful night.
Okay, so we are now on discussion items. What we mentioned earlier, the first thing is the discussion of climate change hazard vulnerability assessment. John, Zago has submitted a document, proposal.
Chairman, Mr. Horowitz, the vice chair, pointed out a proposal, and I directed that. My proposal calls for 2 parts, 11,500 for the initial data compilation, base map, and break it down, and then the assessment itself.
Now, I think we'll go louder.
I'm sorry. I corrected, Mr. Harwood pointed out there was an error in math error. We're doing about 5 of these, so we just got carried over and adjusted, and I've corrected the proposal. The part 1 is 11,500, and then the second part, which is the vulnerability assessment, is another 20,500. The reason for that, it's a lot of work. If you go to the NJDP guidance, we've gotten more involved in these. We're doing 5, we're doing a number of towns now. It's quite intensive in terms of research and writing and analysis that's required. Of course, you know, the board is free to RFP this and see what else is out there, you know, the product of the board. This was submitted to the borough and we didn't heard anything back, and I followed up with the current administrator and I haven't heard anything back. So I guess there's still things.
So there's an uplift, is what you're saying. You've got a subtotal, but there's a,
I would resend it to Denise and she can distribute it to the board.
I think the point is that we approved this contract in July of 23,
Yeah,
right?
it has to be budgeted for.
And there wasn't. So now here we are, September 24, and we haven't made any progress on this. You know, the point is how do we get to see them move forward?
Well, the real incentive here is you have to do it, because what's gonna happen is I imagine in 2025, you're gonna be working on a new housing plan, or not, I don't know.
Well, it's due by June 3rd, so it's per step,
If you choose to participate,
per the law, if you choose.
you know, there's a whole process of determining that. That's a policy decision on the part of the borough, whether what your exposure is to litigation, what it isn't. I know some towns are so fully developed, they're not bothering. They're doing their own housing element and, you know, process be damned, but that's a policy decision. But if you choose to, you're going to have to, and I was surprised it wasn't done when you adopted your first housing element fair share plan. There should have been amendments to your land use element of consistency to reflect. So when I do a housing element fair share plan, I always accompany that with a housing element, with a land use element to coincide, so that the documents are consistent. So that when the implementing ordinances come in under the 26A review, yeah, we've talked about it, we planned for this, this is implementing, there's nothing inconsistent about it. So what triggers the climate hazard vulnerability analysis is your amendments to your land use element, because the state in its infinite wisdom determined that that's the appropriate time to think about, well, why are we putting multifamily in a floodplain area? Why are we protecting wetlands more? You know, why are we zoning this for commercial when it maybe needs less intent? Now is the time to think about that. So you could do it now or you can do it later. Now, what the ramifications are of not doing. I'm not aware of any cases, perhaps Steve, you may know, but
Not yet.
my concern is that if you don't follow this act, someone's gonna challenge your planning and your zoning because you failed to perform the necessary analysis to support your zoning and plan, master plan documents. Has it happened? I'm not aware of it.
there'd be an added
Can it
element
be?
to a case they were making. They'd say, well, we have this and this, and oh, by the way, we have this.
Well,
So why have another?
there's a presumption of validity with our ordinance that's critical, in my opinion. That coincides with keeping up with the master plan adoption and amendment process according to law. So my strong advice would be the next time we amend our land use element, which I agree with John, if we're in the fourth round, in the process, which policy determination will have to be made by January 30, 2025, when a binding resolution by the township with our affordable housing number will have to be adopted, then we will, according to the new legislation, relatively new legislation, March, we will have to adopt a housing element fair share plan by June 30. And I agree again with John that it should be coincident with, or in fact, technically, the land use element should be amended before, could be immediately before, but before, housing element fair share plan is adopted. And what does that land use, element amendment require? Under the law, a sustainability, climate sustainability, element. So long story short, it should be done and probably will have to be done by June 30, 2025.
So how long does it take to actually produce one of these plans?
It takes months. I'm not working on this particular area right now. I can inquire and I can follow up on
I
this.
say 6 months, we're getting close
It's
to
gonna be a
that.
little, it's gonna actually be longer than 6 months. It's that, so, because here's what happens, it's not just us sitting down analyzing data. We need to meet with utilities, we need to meet with first responders, we need to coordinate, what's happening at the state level. There's a lot going on in the area of climate change and resiliency. And, you know, and the good news is, a lot of the information is already in your OEM manual, your emergency manuals, because it deals with resiliency.
It all has to be collected.
It all has to be collected and analyzed, so it's a lot of work. Yeah.
So my point is that we're almost out of time now. I mean, we have about 8 months to do 6 months of work.
If, and again, you know, I'm estimating,
I know.
I don't know what the penalty would be. I don't know if you're gonna end up being penalized the day after if you're in the process. It's like Section 89 of the land use law, you have to do a re-examination at least every 10 years. Otherwise, there's a rebuttable presumption that your zoning ordinances are not enforceable. But it's rebuttable, and I don't know of a judge yet that has said, that hasn't given a town, all right, you've got 3 months, get it done. You know, so, but that's, you're taking a chance. You're trying to be proactive. That's
Right.
what I think you ought to.
And the other point is that climate change isn't getting any better. And it would be nice.
These are Cat 4, heading straight for Tallahassee, they're predicting 100% loss of power.
Yeah. So from whatever the legalisms are, it seems to me that you should be planning for the ramifications of what we see all that about. So my question is, how do we get this thing moving?
But it has to be, look, the board can authorize or can approve the contract, but it has to be subject to funding, and only the council can fund. The budgetary.
Again, how do we get this thing moving?
Leave it to the guy getting.
Well, we have the mayor's liaison sitting right there. You got to talk to the people, and you have a councilman that's the liaison.
Sure, is it?
You know, and unfortunately, you know, it's not here to hear it, but that's what you need to do.
What was the contract? The contract was was approved a year ago, but now do we have to do it again?
Yeah, I don't know if you ever, did you ever adopt the resolution? I don't think you ever.
Yeah, the minutes saying we approved it, right?
Well, it said you voted on it. I don't know that there was a resolution.
But it's only something.
I would have to check that.
I always do a resolution, but we'll go back and check.
I've corrected the numbers, I'll be submitted, and then you can adopt another resolution, and then I would
You want to do another one anyway with an updated
Yeah,
proposal.
I would, well, it's a corrected proposal, yeah,
Corrected.
thank you, and then send it over to the council saying this isn't funded.
Does the council work on an annual budget where they would care whether what hit them in 24 versus 25? You don't have to answer that, I just keep that in mind also.
Yeah,
Might make it easier to get something.
yeah, I mean, I think budget season just ended.
Yeah, maybe.
It just ended, so now you can make emergency appropriations, you know, in November, you can make certain transfers at certain times of the year.
Yeah.
I don't know if it's,
It was a
Before,
resolution.
you mentioned OEM manual. And it's not one of your deliverables, right, an OEM?
no, but it's not, it's a resource that we would tap into, we would definitely want to meet. with
If
your
we
OEM
had an
manager.
OEM.
Your Office of Emergency Management is responsible for preparing
Right, well,
plans and submitting it to the
That-
county.
that's a big if, so let's.
If you don't have one,
Let's just make sure that, like.
I doubt seriously you don't have one, it's mandated. County has to have it,
yeah,
the state needs
okay.
it, and when there's an emergency, you have to refer to it, otherwise you don't get emergency services. I know this because I've been.
Do not presume, that's all.
I know it, I know that.
So,
Yes, don't assume, 'cause-
been there, done that, and You can hear the echo. So, if there's a way to find that out, we should make sure that such a thing, exists for Burnsville.
The way, again, I would adopt the resolution if you wish to proceed. And then a very strongly worded letter from the chairman
Yeah,
to the mayor and council saying this is imperative, it's gonna happen. And then, that's out of your hands at that.
of course.
And then if the board were inclined to vote this evening, you can have a memorializing resolution at our next meeting.
Right,
Um,
I mean,
So the way forward, we're gonna approve the contract, reapprove the contract.
resolution,
By resolution.
I'm gonna send this right to.
And then we're gonna forward that to council, with a letter expressing the urgency of getting this done.
yeah, it's in a box and it's ticking.
Yeah.
Okay.
Steve, can I ask you a question in terms of the timing? If there was a resolution in 23, I wasn't here, there's a resolution in 23. Was it budgeted for? Did
I don't handle that, I'm hearing apparently not.
Does anyone?
Well, the first thing,
It would be
you're correct, the
recent-
first thing you have to do is find out, one, was there, which you were gonna do.
Well, I'm doing it starting now. yes.
Right, if there was a resolution, because that may affect what we do, but we can also vote now, because he'll find out between now and when we would memorialize today's resolution, whether there already is one. We would learn.
Today's resolution is either we're confirming what we did in July,
Yeah, corrected a proposal, it's either the second one or the first, but probably the second, but
Right.
but it doesn't, there's no harm in doing a second one, especially with a corrected proposal, I would recommend it. I'm
Get it
sorry.
done.
Yeah, I was gonna say, it's a corrected proposal. We have a corrected proposal, so let's do it again.
But if the council originally approved, that should make it easier, they
Uh,
don't have to wait.
It had a complete change.
What would happen
there.
if council had budgeted for it, I would receive a signed contract.
Okay,
Because our proposals in the form of a contract, we
Okay.
signed it. We wouldn't be authorized to do anything unless there was a return signed contract.
and you.
And there has to be an encumbrance of funds. So
Okay,
you usually get a PO with that, and then we sign the PO, and then there's a drawdown based on that.
so there's no
Municipal finance
evidence
is
that they were
complicated
budgeted for it,
business.
okay.
So we never received a signed, so I assume it was never budgeted.
Okay, that makes sense.
Okay, we need to take a vote on that.
Steve, just,
It would be this would be a decision with the memorializing resolution to follow, to authorize, the contract with, the Burgess firm, pursuant to the term set forth in February 15, 2024 correspondence from that firm, for the preparation of a climate change related hazard vulnerability assessment, amendment, well, actually element to the master plan. Correct.
It's actually not an analysis, it's an analysis, it's a risk analysis, it's a vulnerability assessment, it's not really a master plan.
That's okay.
So the good news is it's a report, you don't have to have a public hearing, although I know you do this publicly, there will be public discussions, it'll be put on the website, all of that. But it's not a formal public hearing, notices to the county, the state, surrounding communities, things like that.
yeah, not like what we'll need for recreation, gotcha.
Right, it's an adjunct arguably to the land use plan element, but
Interesting.
Yes.
when that's
So
amended,
the wording.
when that's amended, there'll be a public hearing. So that is the motion, and it would be a motion second and a roll call vote, since there'll be a memorializing resolution, and apparently a letter as well forthcoming.
Someone move it?
Mr. Horowitz, a second.
Yes, I did.
Thank you. Ms. Geller,
Yes,
Mr. Graham,
Yes.
Mr. Horowitz,
Yes.
Mr. Walden,
Yes.
and Mr. Zazarino.
Yes.
The motion carries.
Okay, so now we're up to the recreation element master plan update discussion. Which is discussion and scheduling a master plan update. Jeff, do you want?
Well, I guess, know, we last visited this in, I believe it was April of, 2023. At the time, there were some open questions. There were some things that were referred back to, council, as you can see, if you scheduled the minutes from that meeting. And, as far as I know, after that date, there was no further action on the recreation plan.
The plan, but there has been activities
Activities.
related to recreational
Right.
elements that they've been working on or adjusted against.
Yeah, we did have two work sessions on this, and there were corrections made to edits to the plan as per the planning board's recommendations. We haven't followed up. It is an element of the recreational open space master plan, so there will be a public hearing, and notice, but there's no reason not to proceed at this point. The other question I have, though, is that got my plan, we need to bring somebody in from the company that did it, a consultant, to finalize it for the public hearing, just to be here.
If we were satisfied with this plan, what steps do we have to take to adopt it?
If you want to adopt the plan, you would advertise a public hearing date. You have to have notice 10 days before in the paper, the county planning board, and the New Jersey Office of Planning Advocacy. They get copies. All the adjoining municipalities get a notice. They don't need to have a copy, but they generally will come in and take a look. And you have a public hearing and it gets adopted and you adopt the resolution.
Right, and it's just us, the planning board, it's not a document that is adopted by the governing body.
I'm sorry, I didn't understand that.
It's not, we do that as a planning board, it's not a document that is, or it's not like an ordinance that's adopted by the governing body. We adopt the elements, all the elements of this.
Well, due to the time that's elapsed, like I said, there are now. Well, let's call it, there's progress against the plan, things have changed, it depends on what you call progress, but things have changed. As an example, 251 Claremont is now completely different. With different criteria and it should have a different plan for that land. 271 or 267, whatever that is different now, on Morristown, on 206 is different. Kiwanis is different. It's two things. One, how do we efficiently get it updated? The document. And two, it seems to me that one of the key things that was missing here was an affirmation of council's intent. It's one thing for the consultants to say, well, this is what we think should be done. We think this is how things should be, the investment should be prioritized and so forth. There's an opportunity for council to say, well, what do they intend to be doing on this, especially before going before the public? I'm really concerned about presenting this table and list of possibilities out to the public without giving council a chance to say, to asterisk things and say, yeah, we're working on this, we're working on that, we're working on these. These are prioritized items and we've taken it seriously and it helps inform the public who wouldn't be keeping up with council's activities, so.
What's important about the plan is it's a guide. It's a decision-making guide.
Right.
To your point, Mr. Chairman, what happens is they need the plan to be able to go forward. They don't have that yet.
Right.
And my vision or what I envision with this is that with all the goals and recommendations, all the things that are in here, then it becomes a tool for council to start budgeting to implement. And the only way to do that is through the plan and then prioritizing further recommendations of the plan. The council's intent, I think, is expressed through the budgeting process, through the rec committee, commissioner and directors that have to now do the budgeting to implement this. That's the expression. the plan itself is identifying and informing those ultimate decisions that are to come. Without that, the whole point of this was to be able to say, we need to do this, this, and this now. And we can wait on this.
But it's a year and a half later, and they've done these things.
I don't understand why it languished, it just needs. to-
I just don't want us to run into a buzzsaw. You know, that we. One, they've done certain things. What, two, the strategy and the vision has changed for some of these, locations. And I don't frankly know what's in the town's budget for, as an example, how many recreation staff are going to be assigned to manage the recreation properties with a rate, you know, with an expected ratio of people that.
Whose problem is that, though? Is that the board's problem? If you're planning and it's not implemented,
It's
that's
the
a
council's
different issue.
problem.
Well, I'll tell you this problem is, if we have a plan and the council ignores it, it's people of Bernardsville's problem.
I understand that. That's why we have a political process.
Right, and my thought is, what good is the plan if it doesn't at least have some support at council so that we would end up receiving?
My understanding is council paid for this. They wanted this.
Well-
This is coming out of the governing body.
Yeah, well, are they following it now?
I.
Look at some of the highest
Not
priority.
Well, I think my concern would be the way the plan is currently written a year from. Basically before a year and a half ago, because they had to gather all the data. That plan isn't the current plan, like, you would basically have some assumptions that would be, or not even assumptions, but the tables could be different because. Now there's property that's owned or developed, or there's projects that are going on that were mentioned in the plan. That would then change tables and change percentages and change other things, that would then change the way that it's looked at.
That's true of any plan. I mean,
No, I understand that.
you know, that's
but
true of
why-
any strategic plan, master
No.
plan.
No, I totally understand what you're saying, but again, to
I'm not
adopt something
defending
that's
it,
a
I'm
year, right, but to adopt something that's a year and a half old. More than that, when we know things have changed in it.
It just looks stupid.
It's
a plan,
The
and
only
it
way,
says, this is what we're gonna do or recommend for 251 Claremont, which is now leveled. Oh, this would be a great place for recreation buildings, this is a great place for, you know, you can't.
if you're uncomfortable, the only suggestion I can make is send again, the mayor's rep and
Yeah.
council. You need, Chad. Express the concern that it's been a year. What is the council's intention? Because it needs to be updated. You're gonna have to go back to the consultant, negotiate whatever the contract is, if they're inclined to do it. But express that it needs to be updated to reflect the realities of what's going on today. I don't know what else.
One of the notes was, is the consultant giving us machine readable? And the consultant said, well, I don't know if I'll give you a machine readable copy. And when you say, oh, you gotta go back to the consultant, well, maybe we have no access to the source documents.
You don't, but somebody does because you
Well,
bought.
someone does it, not in the town, they don't have access to the source documents.
Mr. Chairman, if I may, the recreation department, director gave me the contact information at the consultant, and I emailed him, he got back to me this afternoon and said he would provide an editable document.
Okay,
Now, I don't have it yet, but
right. Good for you. Okay. You get a gold star.
I find that remarkable because when we do contracts, you're entitled to the documents.
I'm just telling you the facts, okay, and as it's,
I argue that you
okay.
should have it.
I think two things need to happen. One, we have to take the obvious things and fix them. Two, if it's gonna go before the public, when it goes before the public, because it's gonna go, we're gonna do it. I want to give council the benefit of communicating what they are doing. You know, it's not like, well, here's a wish list and here's the way the people prioritize it and so forth. If the council has an opportunity to say, it's in the budget, or we're actively planning what we're doing, so.
Wouldn't that be part of the public hearing process that the board advertised for? If we put it out there, there's gonna be a public hearing,
Right,
bring the public out and have them express their concerns or ideas with respect to this. That's the public comment period that.
this is not public comment.
Well, when you have a public hearing. to
Yeah, there
adopt
will
a
be
plan,
public
so-
comment.
Yeah, somebody can come up and say, why
Before
are
we
you?
do that, I don't wanna pull the rug out under, or stack the deck against the council. I want the council to be able to say, this is what we're doing. I'm trying to be optimistic, and hopefully there'll be items that they are addressing as opposed to, oh, we just dismissed that, we're not gonna do that.
So then what I would suggest is that the board recommend specific recommendations to the council, if they have have a consultant do a public presentation at a council meeting to get you what you're concerned about.
I don't think it needs that. I just think it needs for someone to go through and read the darn thing.
That should be, that should be the direction.
Jack can do that, and the council can do that, and say, this is what you're gonna be asked to do. There are gonna be some touchy subjects in there too, that they've gotta come up with, which is why is there no one coordinating, the calendar? One of the most important aspects of the plan was to have a common calendar that people could use. What have they done? There's some issues there. That's gone on in the last year. So let's give them let's position ourselves for success, ours and the councils. Let's not,
We're on the same team.
yeah,
Yeah.
and we wanna make.
I would think the rec director would be responsible for going through this and making sure that it aligns with what the goals and objectives are.
I think that that's a great suggestion that the rec director be part of that process.
Because for me, this is more of a maintenance, how are we gonna improve kind of plan? It's not an open space. We need to purchase this, it's not a lawsuit type of thing.
I don't mind looking at it that way. Suppose we had actually gotten it paid, passed and budgeted a year and a half ago. Well, someone would have gone along and updated tables by now and said, no, sorry, we leveled 251, so that whole thing's changing. And they would have updated it, and who should in fact update? It's a great question. Who's supposed to update the tables of the inventory? And if it's the rec director in the town, then that's great. So we could approach it that way, so.
Yeah, I mean, Mr. Chairman, maybe, again, a strongly worded letter saying that the planning board is ready to move forward on adopting the document. That the board noticed there have been changes that have occurred over the time.
Yeah.
And we recommend before we have the public hearing that the rec director review this in detail, make sure that it aligns with the borough's goals.
And there's another.
I agree.
I agree with that, there's another recreational area involved, was, as we noted in the minutes of, 2023, Ryan Park. Now, a totally different situation than it was when the plan was put together. So, I mean, there needs a lot of updating on this before we can be adopted.
It's prudent to update. You don't wanna look silly,
I don't
and
disagree.
I think we're all agreeing, it's just a matter of, well, who and how. And, honestly think the council should decide who, but we should suggest these are some choices. And the key is to succeed.
Yeah, Rob, I don't know who the rec, you do have a rec director, Robert Markowitz?
Yes.
Still?
Yes.
Yeah, then they wanna move forward in making sure that prior to public hearing, that this is what they want you to do. And then you could ask at the public hearing, with the rec director here, who's gonna be responsible for updating this and keeping it and managing?
We can't do this ahead of time?
Yeah, you can, you don't have to schedule. The question was, what do we do with it?
Yeah.
And we have to have a public hearing at some point, otherwise we're gonna get further behind.
Yes.
We're gonna have more changes, and it becomes, you might as well, this is an 800-page document, it needs, it's.
That's, now that you mentioned that, it was one of my questions, which is, okay, really, how much of this should be put in the plan versus somewhere else? else. I mean, the single sheets for 22% of the people
The,
never get
the
to
actual
that
plan document is,
There is.
the appendices are thicker than the.
By
document
far.
itself. Yeah.
But where is the right place for that? Is it in the rec director's desk? You know, is it, where versus what should be part of the actual plan document if there's.
It gets put in two places, your offices, because it is a document, it is a master plan document. And it's, and it should be utilized by the recreation department. It's that simple, that's the purpose.
Well, is it normal for a master plan document to be 400 pages of survey questions?
It's not my style. The more, the thicker the document, the more it's just people don't. There should be an executive summary.
Oh, there is. Which there is.
And that's really the focus for the
The
company.
key is what should actually be in the plan, that's all, I'm suggesting. When it's all said and done, what's supposed to be.
At this point, Mr. Chairman, I don't know what the contract called for and what the deliverables were for the firm. I mean, they may have been required to go into all of this detail.
Oh, no, I'm not being critical of that, I'm just saying what's.
I'm not worried about that.
What the elements of the plan should have in them, what should it be? Oh, it needs to be an inventory, oh, there needs to be an executive summary, oh, there needs to be a priority of investment, oh, there needs to be something.
And it has a lot of that.
It does have a lot of, I'm not saying it needs
It
more,
has
it's
an
more
action plan.
pulling the stuff out that's background, that's appendices, and it's like, well, okay, this appendix doesn't really need to be, quote, in the official master plan, that's all. So,
So you'd like to see this called down.
well, I you just take a look at whether some stuff should just not be there. That's all.
You know, the actual plan is about 20 pages, is that about right? 242.
It's about 150 pages, we're not counting the,
Appendices.
well, even before the appendices, there's certain charts and what have you, but it's 150 pages of, well, yeah, the plan is 140 some odd pages.
Right, so that's really the plan, and
Yeah, I'm leading you with what I think
The
the.
executive summary is about 7 to 8 pages.
It's the front, that's the master plan, and the other stuff
yeah.
should be somewhere, and you don't wanna lose it, cause it's interesting data.
Because all the appendices are supporting the.
Yeah, I know.
So I would focus on making sure it's up to date and reflects
Yes.
what it is you're
I was
concerned
my
about.
second comment.
And it has an executive summary, it covers a lot of the things about strategic planning, action planning, priorities, it's got all the right elements. The question is, you want it updated, and I agree with you. And then have a public hearing, the rec director should write a report, say, yeah, here are the changes that I would recommend. And you know what? If they have the digital copy, they can do it.
Yeah, they could do it,
They can do it.
they could be done.
Yeah, and while there were workshops and what have you, as, and perhaps everybody knows this, but the actual, as far as I understand, the last, draft plan document is more than 3 years ago, more than 3 years ago.
You know, Steve, that's where I thought the document dated 2021,
Yeah, July 2021.
but then there was a sheet of corrections.
Yeah, I have all, there's,
And that-
later edits and workshops, and then, May 2022, we had a presentation.
Right.
But I never saw a document that actually incorporated the changes that were in that sheet of changes.
You did or you didn't?
Did not.
I don't.
No, I don't say I never saw it. I don't have it.
Right, and I have the changes that I think, but I don't know that they're undated.
Yes,
So,
they're undated, and I don't think they were ever incorporated because there was no.
I think the
editable
intent
document.
was,
Right.
That
for them
was
to
what I
come back.
discussed with, Bob Knuckle today.
I'm sorry, I think the intent was to go over those changes prior to adoption, and they
Right.
just never came back.
Right,
I don't know what happened.
well, they weren't an outrageous number of changes,
No, well-
but I think we have a path forward here, we've got a victim. Namely the rec director.
Well, so what's that? Let's spell it out. Let's see what that's going. You're gonna,
We're gonna make sure, we're gonna, Denise is, we're gonna find out if there's,
And then we'll-
editable document, and then we have.
Yeah, I'm hoping to be able to get that.
We'll confirm that the updates never got into that editable document, that makes sense. And then, whatever the most efficient way is of asking the I guess it's asking the council to ask the rec
Director
director
to,
to review, for progress on this,
and update
vision and plan and update it.
from
So how do we-
roughly 3 years ago.
Express that to council.
We give it to our flooded, Chad should be carrying it to council, right?
Oh, well, that's not, there's no formal requirement. I mean, you communicate with Denise frankly, that at this point, any way you want to do it. There's no.
You know, it's not improper, I wanna do it with it.
Yeah, I mean, I'm gonna let John, since it's a master plan element, and John and I can, through Denise, make the requests,
Okay.
to forward to the rec director, to forward to the council, et cetera. Actually, actually for the council.
What happens if nothing ever gets done, it's just languishes forever?
She said nothing ever gets done.
Well, we'll get them.
It's not like they're oblivious to.
It'll get done. It'll get done.
Oh, is there a penalty for not having an updated
No,
recreational?
no, it's an optional.
It's
It's an optional,
optional.
all you need is a land use element, the statement of objectives, and a fair share plan. Housing element, fair share plan.
Under section 62, you don't have zoning without those two.
Yeah, and after that, all you have, when I say all you have to do, we do much more, and we always do, but all you have to do at a minimum is every 10 years, you don't even have to do a new master plan, just a master plan re-examination report, updating, in essence, the master plan. Those are the legal requirements.
Right.
We go above and beyond, and so, at that point, of course, you're in the realm of discretion.
I mean, there was a lot of outreach, there was a lot of discussions that went into this, and, I think that it's a good document.
A big investment was made. I have every expectation it's gonna be updated, in the near future and the board will be adopting.
Yeah, and in the executive summary, as far as the action plan, it says an action plan of 129 strategies and recommendations were listed. I haven't found it yet, but of the 129, maybe 5 or 6 of them have already been done. So, I mean, that's something where, 129 seems a little much, but.
Another way to do this, and I'm just throwing it out there, is to do I don't want to call it an errata sheet, but an update sheet that basically says, we're amending this with these changes, and adopting it and identifying it, and maybe elaborating it.
Why don't we ask that to be the deliverable?
And that way you don't have to rehash and redo the entire thing. Just do it, that should be
We'll
updated.
just specify that that's the form of the deliverable, it's,
Could be 5 pages of, here's what's been done since, and the plan is hereby amended to reflect these changes. Done, and then.
and it's not just done, it's also dismissed, they could also be like, it's been addressed.
Is that acceptable to the board? I'm trying to get this thing
Yeah.
done.
I just want it to be current, so when we get into meetings,
Because what's gonna happen is if you're gonna have to insert or go through 150 pages and try to find tables and it'll be quite an effort. I've been in those situations. It's not fun and it's expensive. Do an addendum sheet saying, here's what's happened since.
right,
We've updated it based on this, and every year we'll do an update. And you don't have to necessarily do that as a master plan thing. It could be as simple as a report from the rec director to the council saying, here, we're following this plan, here's what we did this year, keep records of this.
yeah, it may work. We should provide that as an option. It's hard when there's like a paragraph on a piece of property, and what should be done with it, and it's like, oh, well, if you look at the update, that all's changed, so. But we need, the point is to make sure it's efficiently. That it's not burdensome. It shouldn't be burdensome to a rec director to go through this plan. That's kind of
That's their job.
part of what they should be doing, so. Given the opportunity.
So what is it that you're directing me to do? Want me to write the letter?
You're gonna listen to what Steve says.
It's-
Yes, well, you almost like you always do.
He's gonna write the letter and I'm gonna rewrite it.
What do we expect the rec director to
I'll
do?
draft something, I'll send it to Steve, Steve's, after he edits it, he'll send it to Denise. I think you should sign this.
Yeah, that's okay,
I think you should sign this.
Yeah.
But we
that's
can-
fine with me, and you know, we're not asking for any of the facts, the surveys, the charts, any of that stuff to
Just update what's changed.
to be changed at all, it's just
I
that's
was
a matter of
just a
record.
garage.
Look for consistency in the master plan and the priorities of investment and the inventory, and just see what's been done.
You can do that.
Recommended changes.
So, if it's the pleasure,
Well, they have to deliver the deltas, yes.
if that's the pleasure of the board, we don't need a resolution, but a motion second and a voice vote to direct John and I in that, and Denise in that regard is more than enough, frankly. So moved by
All three barrels, so,
Vice Chair
all right.
Horowitz,
So move.
Second.
seconded by Board Member Geller.
All in favor?
All in favor?
Aye. Any opposed?
We are direct.
Thank you. I think the key though is make sure that we have to make sure that the rec director gets all of the artifacts. When they're, you know, the changes that were there, you know.
CC. Denise, you'll shoot us,
Okay,
you'll double check on the, if you have a workable document, when you have a workable document, you'll also copy in the rec director, so John and I can.
Well, I copied him on my request, because he was the one that gave me the email address, so I will.
Get in touch
That's all,
with us
yeah.
all. Thank you.
I'm gonna open it to the residual public that may be here to see if they have any other ideas that you've heard what our next step is, if you have any other constructive idea that whether we should do anything different.
When I hear what you're saying, I just feel like if we're gonna have.
I'm sorry, technically,
Technically,
you don't have to be sworn in, but just name and address for the record.
Carrie Hazelton, 397 Minebrook Road.
Thank you.
I sit on the rec committee, and I was on the master plan committee that worked on this many years back. Yeah, there are a lot of things that have been done, there are things that have changed on the properties, there's name changes, those things are kind of minor, but I'm just concerned if we go forward with a plan of creating errata sheets or updates and appending them onto the front of this 150-page document, it's gonna become, after 2 years, 3 years, pretty cumbersome to try to look at those front pages and then go to the back pages where that they refer to. And I do think that if you wanna create a good errata sheet, you are gonna have to go through the 150 pages to look for the things that you're gonna need to put on the errata sheet. So I don't think you really,
So you might as well do it.
you might as well go into the document and make
I'll
change.
volunteer to update the document. Okay, but I want the input from the rec director, so,
That's quite.
as long as it's not in like. Word Star or some, you know, I gotta get my TRS-80 out or something, take it in, so hopefully it's in an editable. Modern word processor.
I'm sure it's gonna be cool.
We'll get that, I agree, we can get that.
Aaron Duff, 51 Crestview Drive. I have a lot of thoughts. I've been thinking about this for a long time. It's been years. And I'm gonna try to not go off on tangents. I'm gonna give you what my recollection is on the history and where it came from. When we had the open space referendum back in 2019, saying, okay, this money was previously dedicated towards acquisition. That's why we had an open space advisory committee. They were out there, what are we gonna buy up to have open space? Now we have this referendum. Now all this money can be used for improvements to recreation facilities, not just acquisition. And so, okay, well, we have an open space master plan, but we need to have a Parks and Recreation master plan in order to guide council's decision-making and investment priorities with respect to the allocation of that new source of, tax revenues coming in.
Right.
And so, that's where this came from. Now, the council's role, and I think we have to kind of separate, and when you start talking about master planning, separate out, you know, the roles of the different, municipal bodies in that, you know, in that circumstance. And so what the council did, they said, hey, you know, we need a professional. Let's get, you know, some expert guidance on this. And so they hired Vance Carroll. But they hired Vance Carroll to advise the planning board. The planning board is the master planners, the ones who are not just guided by, you know, whichever way the political winds are blowing, let's invest in that, let's invest in that. Let's create a plan to make sure that we're meeting the needs of the municipality in the most efficient and way that meets the community desires and what's best for them.
Like the gatekeepers of the master.
Right, and then when I say guiding, I'm not saying that you're not in charge, you set the master plan and the council can choose to ignore it. There are certain other steps that they have to go through. If they're going to invest in a way that violates or directly contradicts the master plan, they can do that, they just have to give reasons on the record. Well, correct.
And
In order to maybe some other things.
two-thirds majority of the full quantum.
So you're a gatekeeper, but you're not the one spending the money. And digressing again. So, okay, so, the professional's role, and I think we spent $90,000, whatever we spent on this professional, to come in and do what he did. They had a statistically valid mail-in survey, went out to the whole community, everybody, you know, pitched in, they had an online survey, they had meetings with focus groups, all those different things. And so they came up with this report. Now, back up a little bit. I don't know any way to say this, but somebody at the borough royally screwed up the contract and had the professional's contract only go through the presentation to council instead of through adoption of the master plan. This was always a master plan report. It should have gone through the adoption of the master plan by the planning board. So you'd have Vance Carroll here presenting their report and telling you why this investment is here and that investment is here, and we left this out, we put this in, all that stuff. That's the reason that we're in this situation that we're in, because the contract was screwed up. And so when we went back to Vance Carroll, said, oh, hey, you know, we're not done yet. And they did make a presentation to council. The council signed up, said, hey, looks great. Send it to the planning board. This happened. I was there. You know, like that definitely happened. They didn't, you know, there were public comments. They said, are you sure about this? And Vance Carroll, yep, we'd like to. And council said, great, send it to planning board. Terrific. Then when we went to say Vance Carroll, you know, Frank Matola went to schedule him to come in and make a presentation. They went, that's not our job. We didn't even look at a contract. We only had to make a presentation to council. And so they wanted, what, $8,000 per appearance here before the planning board to support their report. And the planning board said,
Per appearance?
I believe it was they wanted a lot of money. The planning board did not want to give them all the money that they were asking for to come in and present it. And so we had these working group sessions, and Bob Markwick appeared at the last one. I love Bob Markwick. I think he is a absolutely wonderful and competent, you know, terrific public servant. I'm so glad that we have him in our recreation department. I don't think this is his job. You know, I don't think that, you know, the formulation of a parks and his job is to follow the Parks and Rec master plan that this board adopts. So look, if you want to use Bob as a, you know, I don't know, a steno, exactly, like say, look, here's the changes we want to make, Bob, go make them. I don't think you want to do that.
The inventory. In other words, what has he already done? You know, like, okay, well.
It's all in the report. Whatever's in the report is in the report. That's the professional that we hired and paid $90,000.
No, not that. That's all. There's a lot of stuff that's.
So there has been stuff that happened. And if you want Bob to say, look, they knocked down 251 Claremont, this needs to be changed.
Right.
Okay, someone needs to do that. I agree, absolutely, 100%. Someone needs to do that, but then, well, what do we do with 251 Claremont? It's not Bob's, like, he's not a policymaker, he's not, so that is something that needs to get figured out. It's also not council's decision. Eventually it might be, But what the master plan says to do with 251 is not council's decision. You know, you might decide to 251, well, we really need indoor recreation space, and let's build something on the footprint that we just tore down.
Pickle quotes.
Whatever. It's your, that's this board's responsibility to
Right.
plan. Then the council can choose to go along or not go along with your recommendation. So that's the stuff that's changed. My issue is, look at the other 155 four pages and a half pages of stuff that, like, you know, really has no been minor or no like facts on the ground change. Well, there are a lot of recommendations in there, like you said, like 100 something action plan. Who's gonna back up action plan point number 111? If they're not here, why'd you put that in there? Well, I think because either Hatfield and McCoy's told you to put it in there, you know, as you previously characterized. But, you know, like without that, you know, like, is Bob supposed to say, why is it, I don't know, I didn't write it. You know, like, so I think as much as we might, you know, wanna, you know, pull our nose and just, I think you gotta pay Ben Center Carroll to come back and present their report. I think they should be the ones that change it. You could tell them, hey, you know, 251 is not there anymore. This changed, that changed. Update your report. They can do it hopefully a lot easier and less time consuming than we will. And come back and present it. And look, I don't know if, you know, what was said to them or what, you know, they're down in where? They're in Alabama somewhere. They're in the South. So they're not like somebody we're gonna use again probably, but like, I don't know. I think we gotta get them back. I think other than that, the public hearing is that it's not gonna be a meaningful exchange. If you know, somebody raised their hand and says, well, why did this action plan call for investment of like $200,000 in
It
a
should be here.
disc court through the woods? You know, disc golf through the woods. Why are we spending money on, why is that in the master plan?
Can I ask you a question? Don't you think it's important to have the stakeholders who are going to implement the plan? So the recreational director to look at this before we approve
He
it.
should be here to say, this is totally unworkable, but he should not be altering the plan before you consider it based on what he believes is workable or unworkable. He should be presenting that's an unworkable suggestion. Don't do that, planning board. You say, thank you for your input, Mr. Markwick. I value your opinion as a, recreation director of X number of years in your experience. Thank you. We will weigh that accordingly.
Well,
Is what I think.
Isn't that what we were asking for him to take a look at it and comment anyway? Isn't that part of what we
did not
discussed earlier?
explicitly ask him to comment on the feasibility of any one of the topics. We just asked him to update the reality of it and anything he knows is gonna happen, you know, he has some idea of what may be happening in the next 6 months. They indicate that. We did not ask him to say, disc golf on a hilly surface would be, is imprudent.
I would maybe suggest that, Ms. Geller, I think you're right, that like maybe you would have like HPAC provides you a letter, when you're having a development within a, historic area. Maybe he could write, a letter, I mean, it'd be a long letter because we're going through 155 pages of master plan, but maybe like, things that might jump out to him, as just here's my expert or whatever you would call it, my opinion as your recreation director on XYZ aspects of this master plan that jump out at me. But I don't think he should be guiding decision-making or, he's not a gatekeeper to what gets presented to the planning board. I don't, in my personal opinion.
Right, so there's a vision and the topics. He could do things beyond correcting and adjusting, and the reality, we could say, what's the low hanging fruit here?
Well,
What are things that are easy?
I think that's part of the public hearing.
I thought that was all done, and that's what the outreach was for.
No, low hanging fruit wasn't done.
Well, wasn't there discussions, the rec director wasn't involved in the preparation and stuff
Right.
at all? I mean,
There
there had to be
priority
collaboration.
priority initiatives, but that's different than what was asked.
And in my opinion, and I believe Mr. Fuller said this at the last, if I remember 2022 correctly, look at the action, look at the priorities. It's like, it's a Greek diner menu. It's, like you can do literally everything you can do in our parks. There's no like, it's 3 categories, high, medium, low, and like, and they're not, there is no prices. next to any of them. So like, well, does it matter how much it costs? I don't know, like, so it's a mess is what it is. And, you know, that's why you need somebody to say, you know, what it makes sense of this, or like put it in a way that will actually do what it's designed to do, which is guide investment, rather than just say to the council, here, you know, you want, you know, scrambled eggs, or do you want filet mignon?
Well,
And you can, and then then it's not a master plan, it's just, you can do anything, go get it.
the cost may have to come from the director. Because he's gonna deal with, you know, capital, he's gonna deal with what does it cost to maintain, once you built it, how do I keep it up, and how many more
The
people?
council, yeah, the council has to talk about
To
it.
give, but obviously providing the council, but they're they would prudently be asking him anyway
Sure,
for that,
that's my thing.
aspect.
Thanks. You know, one of the problems with this plan, there was calls for a review of progress on the plan every 3 years. I think it's every 3 years. There's no process for review. And anybody who's gone through a planning process of corporation knows that you have a reporting requirement. That every periodically, monthly, yearly, just whoever's in charge of implementing the plan has to go back to the board of directors and say, here's the progress we made. And, you know, that's not.
The land use law actually provides a process for that.
Right?
That's a great point, but there is a plan for that, that is covered.
But there's nobody given that job.
No, yes, there is.
The plan.
The rec director actually has the job of reporting progress every month to the council. So, oh, well, he's got this other piece of information, which is, here's the table, how am I doing? That's easy to incorporate, you know, that element into what his report is to Nancy.
The other one,
The missing part in all this,
What?
there's a missing part to all this, and it's the coordination of capital improvements. And the land use law actually provides for a mechanism for capital project review. And I remember doing this as a kid out of college in Elizabeth, where the council is a provision in the land use law says the council may delegate the preparation of a capital improvement plan. And what happens is it's a 6-year plan, and every year all the departments came in, talked about their capital expenditures and how, and your job as planners was to gauge it against planning documents that you're familiar with, that you have a role in, like this. And every year, they would have a 6-year, and then you would have the opportunity to say, what happened here? Well, you know, funding dried up on that grant, but we got another grant, we could do this. It's a laborious process, but one that is provided for in the land use law. But you have to convince council to delegate that to you.
Right.
So my point is, there is a capital plan. It's part of the budgeting process.
Well, by definition, there's a capital plan.
Of course, exactly.
De facto, of course, there is one, you know.
And you guys can coordinate that if the council wants.
It's in it, although you get, like you said, into all the different grants and funding and financing and so forth, so that it's not capital, it's something else, you know, that.
Capital meaning expenditure of tax dollars for infrastructure. That's what this is. But that's a whole other
So
level.
we are nonetheless faced with a daunting list, like I said, 120 or whatever, you know, items, that it's not just like, here are the 6 things you ought to do. You know, that kind of, but there are just 6 things that they're gonna do. You know, that's one of the challenges, that they're only gonna get to 6 or 7 things, you know, in a given year. And that does create an exposure in the public meetings when we're not armed with cost, essentially.
The cost, I mean,
It's just an exposure.
you know how volatile things are with cost. You have to bid everything just to get updated numbers.
Right.
And that's part of the process of developing a capital plan. You have to do bids.
Well, that's a good excuse. You just, it can come back to it's just Santa's list, and I've got 121 items on it that I'd like, and I guess the parents will figure out what I'm gonna get, you know, so. But sorry, they'll talk to Santa.
I gotta work cold. You were lucky.
So let me just follow on something Mr. Doug raised. When we have a public hearing on this, what is that gonna look like if we don't have somebody there?
You have to have somebody here. To me, what's unusual about this is the consultant should be presenting this at the public hearing and defending it and answering, just like Mr. Duff said, questions about this and that, which it's their plan. I would never ask someone, if I did a housing with a fair share plan, I wouldn't ask Mr. Duff or someone to come up and explain it or edit it.
I might, no,
Well, you're chairman of the planning board, you may.
don't get to be
You
clear.
may take issues with it. My point is that I'm responsible for the documents I write.
But my recollection now that Aaron mentioned it, was they did ask for a lot of money to come back and do that presentation. I don't remember the number, but I remember it was a surprising number. Okay, so we have a motion on the floor, which should we withdraw that and?
No.
I don't know that it's changed. I think maybe we've gotten, with the assistance of the public, great assistance from the public, maybe more clarification as to what the expectations are and who might be doing what, and who might not be doing or shouldn't be doing what. Because yes, the policy does not come from the recreation director, and the planning board is, as both Mr. Duff and I often say, the gatekeeper is the master plan. So and the governing body has the purse strings, I think we're still pursuing the same thing. The question is,
Draft something up and circulate.
yeah, we'll do that. And you know, maybe the errata suggestion, 'cause I was thinking the same thing.
Yeah, it's
Now, if we have an editable, is that the right word? Electronic version of the document.
we can't, I don't know if we can. I don't know, my documents are sealed, I don't want anybody
Well,
messing with my.
let's find out what we got first, but I agree, you know, doing it in one comprehensive document is much better than having to go to a errata sheet.
So you get searching, moving.
You know, even if it's not editable, machine readable, still.
You scan and you do it.
Should we recommend to council that they retain the consultant to conduct the public hearing?
I'm sorry?
Should we recommend to council that they retain the expert to do the public hearing?
I would. They wrote it in collaboration with the community. Bring in another, it's like passing litigation that's so far ahead and giving it to another lawyer, it's like, you reinvent things on wheel, it's gonna be very more expensive. Definitely.
Did the contract read that they would only present once?
My recollection is as, you know, you forget these things, and then you hear them in George and memory. My recollection was that the presentation for the council was the end.
And was again, I know you don't know the exact amount, but was the amount they threw out reasonable in light of their hourly fee? Or were they simply
I
saying
think
we're not?
the sense was, it was 4 figures for sure. And I think the sense was, why do you need that much money? You weren't being asked to do any more work, you're being asked to show up in one meeting.
Yeah, way beyond what their hour costs for, yes.
And when you're dealing with the municipality, aren't there certain guidelines? They can just. Who did
It's
that?
known as a professional service contract, you don't even have to do that more if you don't want. But, it's always good to get multiple RFPs on things, compare. They warn you, the lowest bidder is not always the
We
best.
should give the council a heads up. Chad's not here, but let's give a heads up. There'll have to be a public session in the foreseeable future on this. There's a very good chance they will have to engage the consultant to participate in that public hearing. Do there have to be 2 or one's? We don't have to have 2 hearings, do we, or do we?
Yeah, one hearing.
One hearing
is the minimum required.
I mean, it could be one with a consultant and one without if we needed another one, but. But you know, I asked the question because maybe there had to be 2, I don't know. And we need a location to hold it, and potentially there's a number of things, or we zoom in. You know, so those are logistics, but let's give them a heads up.
It would be cheaper to zoom in, you could get as many people as you want.
Including them from Alabama.
They could zoom in from wherever they're from to
Maybe that would make their costs less if they didn't have to come here,
fly,
fly,
hotel.
hotel,
Rent a
exactly,
car.
maybe that was part of the cost.
Right.
It'll just become evident it's not an hourly or a travel charge, it's it's an intellectual property charge. That's what
Well, I have a question thinking about this. One of the things that Mr. Zabo said was if the consultant prepared the document and we asked for an editable document, I would think it wouldn't be appropriate if we edited the document and then we expected him to present
Yeah.
his document with our edits,
It doesn't.
right?
So we prepare a red line document.
You can prepare a red line document.
And give it to
Okay.
him.
Here are
He's gonna
comments,
prepare it if he's going to present it.
which is very.
Right.
Because will have wanted to know that anyway, right?
Right.
He doesn't want to be talking about a site that no longer exists.
Exactly.
So.
Right.
So now we're redlining, but we're also updating and we're also trying to get some
It's always
some
sometimes.
practical information
So
from the
you want,
governing
what you're
body.
looking for is a relevant document. In your mind, it's not relevant because it's outdated.
In my mind, it's severely flawed right now.
Right, so it's
Because
outdated, it's
actually
not
they have
relevant.
made some progress.
I'm
Well.
just thinking of words.
So I guess the point was, do we need to provide any additional guidance? You're gonna write the letter up. So we were, and from the letter, we'll know what guidance we're requesting the council to ask the rec director to provide. Clearly, we want to know the facts. We'd like to know, I think, what they already have on their agenda and what they intend to do, because it's in the budget. And, then there's this whole separate question of just asking, Bob if he wants to take a shot at the 120 in terms of easy peasy stuff or crazy stuff. But that's not the critical thing is to just get it to be current. It would have been a logical next step anyway to ask the rec director, what do you think about these 120 items that the consultants recommended? It would have been an appropriate activity. What else? So, we voted, and we voiced voted.
Yeah, we have a question. Again, that frankly, the formality we went through to get there isn't required.
Okay, great. Anything? Thank you for your comments. I think that's. So we've got the schedule stuff, no more, anything else? Yeah, go ahead, you actually have it. You can comment in.
Thank you. Aaron Duff, 51 Crestview Drive again. I have a procedural question, I guess. My reading of the municipal land use law requires a board to memorialize the decision that it took on a site plan application within 45 days of that vote being cast. When I look at the calendar, counting from this board's August 15th special meeting on the AR at Bernardsville, site plan application, which was denied on that night. I don't see another meeting of this board between now and that 45-day time period. So I wanted to know whether that resolution had been circulated, signed. I don't know if it has to happen at a public meeting or how that works, but where's the status of the resolution memorializing the board's denial of the air at Bernardsville application on August 15th?
I can answer that for Mr. Duff and for the members of the public. Couple of things. First of all, any consideration of any memorializing resolution and adoption thereof is done at an open public meeting. So that will not happen until it's done in public, in an open public meeting. Sunshine notice. that particular resolution is not complete yet. You are correct in that the MLUL does have a 45-day provision. The way it works, because oftentimes, not as often with us, but more often with most board attorneys is that it takes a couple of months or more for any resolution to get adopted. We're generally next meeting or the meeting thereafter, we're usually within a month. This particular application was somewhat protracted, quite a bit of information, et cetera. And there is more than a reasonable basis. And we can't discuss the substance or do anything that's client privileged outside of executive session even. But I think one can speculate that a denial may lead to an appeal. So the way it works in practice is the only way to enforce that 45 days, and it's usually done by the applicant, who either wants the approval or wants the denial so that they can appeal it, is they go to get an order show cause in the courthouse to compel, and judges at least, and I don't have experience with that, by the way, and I frankly pride myself on not having experience with that.
You get a that.
But that is how I'm told it works in practicality, and I've seen with others. So if anybody wants to make an order to show cause to compel a sooner rather than later memorialization of the resolution, which may just lead to a sooner rather than later appeal thereof, they can do that. I don't want to make any promises, but suffice to say, we anticipate having a resolution relatively soon for the board to consider memorializing, or I should say adopting, memorializing that decision. Once that happens, then there's a 45-day period from the publication of the notice of adoption of that resolution for anyone to appeal that decision. And then after that expiration of that 45 days, if it's not appealed, it's not appealed.
Notice and things like scheduling it for a meeting and notice for the meeting.
No, they're for memorializing resolutions. There's no process other than it must be done at an open public meeting.
The remedy in the law is the applicant can compel.
Yeah, order show.
At the borough's expense.
And that's kind of where I was going as well, because my reading of that statute is any party, any interested party can, not just the applicant, any interested party can, come in, go into court on a summary action and tell the court that it's 45 days, 45 days. It doesn't seem like it's, at the planning board's discretion to extend or, take longer with that. It's a mandated, time period. And if an applicant were to do that, yeah, they would get their attorney's fees paid out of my pocket, out of the, municipal taxpayer's pocket. And my other concern was how it, there was, discussion of, the applicant coming back and asking, for a reconsideration here. How does, does any delay in memorializing that vote, in a resolution within the mandated 45-day time period told the time period within which the applicant may come back before this board and say, hey, I know you haven't gotten around to this yet, so, excuse me, I want to do it again.
Yeah, no, and with the chair's permission, I'll answer that. And again, well, a couple of things. One question that wasn't asked, but is my understanding, at least, that the applicant has no intention of going into court to compel a memorialized resolution to be any sooner. It's also my understanding, again, not having had this happen, and I'm glad, and I anticipate that never will, but for me, but the happened for is that what I've heard is that in the few times that's happened to others, more than 3 times. What the court generally does is say, how long do you need? And give you 90 days or 120 days or whatever. And more often than not, I think from what I've heard, by the time the process plays out, the resolution's adopted. Just like cases settle often before trial. But, and I'm sorry, I just, I went too far afield that I lost my train of thought. But, what was your?
There's still a risk potentially that's.
Well, no, because,
third
frankly,
party.
the second somebody, you know, before any court hearing, you'll adopt the resolution. Oh, reconsideration. That has no bearing on the, does not benefit and, the, potential movement for reconsideration by virtue of the memorializing resolution being adopted on a 44th day or a 45th day or a 46th day or beyond.
So
It does not benefit
I guess my question,
a potential movement.
correct,
And as far as I know, because I heard what you heard, we have a potential movement. I guess you always have a potential movement.
well, that's what I'm saying, do you have a potential movement after 45 days? Or is your response to a motion you received on day 47, you're out of time? Even though I haven't memorialized this yet.
No, because I
you're outside
think
the
my
45 days.
understanding was that there isn't a specific deadline for moving for reconsideration, whether the resolution is adopted or not. Now, if the resolution is adopted and the 45-day appeal period expires and that potential movement for reconsideration has not moved for reconsideration nor appeal, then certainly one would argue that, well, if you cannot appeal now, you cannot move to reconsider.
Sure.
So that is a line of argument. It's all a little speculative because we don't know if the potential movement intends to move. We don't know if the potential appellant intends to appeal. And if they do intend to do one or the other, one might presume that they're gonna move to reconsider, they're gonna do so before they appeal. And if they ran out of, if they butted up against the deadline to appeal, they'll appeal before that deadline expires.
Sure, I was just, there's a lag period in there, 45 days from the vote as opposed to 45 days from the enactment of the resolution, which would be the appeal. All that time in between is my concern, but if you're telling me that it really doesn't matter because there is no, set deadline on reconsideration motion, then that answers my question.
No statutory deadline, and frankly, as far as I know, not even one case law imposed, but you can make that little argument, sir.
Thank you.
So, sure. We, talking shop, I guess. But happy to do it, always.
Okay. No executive session.
No, exactly, yeah, but we close, yes, but not, we'll never go over the line. No executive session.
It is 9:30.
I don't think anything by plan.
Oh, God, like, wow.
I thought.
Right.
Are they considering the messages?
Yeah.
No, I wanted to know, so well, what if
To a layman, exactly.
yeah, somebody wanted to knock on the door, and even climbed in my name, and I was kind of. Consideration somewhere available.
I know. It's lost regarding, there's not a CO, there's no well.
Get the text messages and.
I think I should do, I think more of them, however, some people not issues that it's before. I don't, this is not why they should mark it, it's an eye order. Usually. So I get like every other day. I just figured.
I think
Yeah.
It's silly, it makes sense.
And just so you know,
So. I think it was correct. Here's a tomato.
Yeah. Well, my dad's in Fort Myers, so we've been checking on him tonight. I was actually, my sisters were.
So right up the middle of Florida.
And then there's like a
But this thing's big area. So shots from now is.
I haven't.
This
decided.
is, it's a cat four, which is the worst. Cat five.
Yeah.
20 feet. The breadth of this thing, they've never seen anything like it. And it's building. Because the water is very low.
Yeah.
25 degrees. It's just heating, and there's no wind. There's no backwind to it. It's generating its own energy. So.
Is that like a cyclone?
Yeah.
As it's spinning, it's bringing water up.
They usually just build those water jugs and whatnot, but if it was inside.
But we'll see, I wanted to, okay?
Well, I spoke to him just before the meeting, and I said, today it was raining on and off, and it was just very windy,
So.
but nothing crazy, yeah, so.
Keep it up.
Safe harbor.
Rainwater, yeah.
Process, as I understand it.
So that has to go.
But they can do that, so.
So that's the.
Yeah, but I don't know, we're gonna have to go to court. No, whatever, I would never play that.
Was that Oh, yeah, there's.
It's just a matter of getting it done.
The-
Done right, it's probably times, and candidly.
No, it's there, it just stays.
It's just there, right,
So what do you do when you have two hearings?
No, no.
It's,
So much.
60 or that way, what we said.
And you don't want to go out most real quick.
Facilities that you go to, all of the concessions are on